Welcome to the Rational Egoist. I'm your host, Michael Liebowitz, and we are very honored to have with us here today somebody who fundamentally shaped my thinking on constitutional interpretation and the nature of a just government. He is the Patrick Hotung Professor of Constitutional Law at the Georgetown University Law Center and is the faculty director of the Georgetown Center for the Constitution. He's also the author of numerous articles and books, including one of my favorites, Restoring the Lost Constitution, The Presumption of Liberty, and his latest, his memoir, A Life for Liberty, The Making of an American Originalist. Professor Randy Barnett, welcome to the show.
Well, thank you for having me. I appreciate it a lot, Michael.
So one of the ways in which you helped me to clarify my thinking was in my introductory law classes, I was always taught that judicial review is not part of the Constitution, that this was a power usurped by the court by John Marshall and Marbury v. Madison. But you argue, no, that's not the case, that it is a fundamental part of the Constitution. How so?
That's just demonstrably untrue. And I would think that by now, people would have recognized the fact that the evidence that something like judicial review, not by that name, was clearly considered to be part of the judicial power. I mean, the evidence is just overwhelming. By the way, who did you have for constitutional law that taught you that misinformation?
It was just my textbook. It was,
Textbook. Okay.
yeah.
Well, anyway, the evidence is overwhelming that courts believed that the founders believed, the founding generation believed that the judges had a power. I mean, I'm sorry, not a power, had a duty to follow the law, and that the written Constitution was a law that superseded statute. So that if there was a conflict between the higher law provided by the Constitution, which stems directly from the people, and a lesser law coming from the legislature, the courts needed to follow the higher law and disregard or treat the lesser law as though it were void. Now, this was not called the power of judicial review. In fact, the phrase judicial review didn't even come into use until the end of the 19th century, and the power of judicial review did not come into use until the 20th century, in part to diminish, I think, the inherent duty that judges have to follow the law. If in fact it's not a duty they have, which you simply have to do, but it's a power they have, which can be exercised with what we might call restraint, then this power should be exercised with restraint, which means they might or might not exercise it, as opposed to a judicial duty, which they absolutely have to exercise. Now, you can see this identification of judicial duty in the Federalist Papers. In Federalist 78, it's very prominent. It's prominent in judicial opinions prior to Marbury. What makes Marbury stand out is it's the first time that the court actually held that an act of Congress conflicted with the Constitution. But prior to that, the court operated frequently with the assumption that it did have a duty to follow the higher law and disregard a statute that was in derogation of the higher law. Repeatedly, they simply didn't find that the statute met that requirement, and state court judges were doing the same thing.
Thank you. Now, you differentiate between construction and interpretation. What is the difference?
First of all, the terminology is not what's important here. It's the
Okay.
concepts that are important. And even though this terminology is now become rather commonplace, and it dates back to at least the 1830s and the writings of Francis Lieber, it's the two activities that need to be kept separate. The activity that we now call, or I now call, interpretation, is the activity of identifying the communicative content of the text. That is, what information is actually communicated to the reader by the words of the text of the Constitution, or it could be the statute or whatever. Is that if you're engaged in interpretation of a statute, if you're engaged in interpretation of a contract, the issue is, what is the communicative content? What information is communicated to the reader of that text? That's the act, and figuring that out is the activity of interpretation. Having figured that out, there also becomes a separate activity, and that is how you give legal effect to that meaning. And the activity of giving legal effect to that meaning is the activity that's now called construction. And what do we mean by that? For example, it means developing constitutional law doctrines to implement the original meaning of the Constitution. Most of what you study in constitutional law that we call constitutional law are judge-made doctrines devised to implement the meaning of the text. And those doctrines are either faithful or they're unfaithful to the original meaning of the text, but they don't come from the original meaning of the text. They're not deducible from the original meaning of the text. These are doctrines that the court devises in order to apply the original meaning of the text to cases and controversies that come before it. And if you don't recognize that these are two separate things, you can get yourself into big trouble. And many of the justices continue to get themselves into big trouble when they confuse the application of original meaning with the identification of original meaning.
See, you just used the term a couple times, original meaning. Prior to reading your book, Restoring the Lost Constitution, I was someone that would argue for an original intent. But you will demolish the idea that it's original intent that matters, and instead it's the original meaning that matters. How do they contrast?
Okay, so let's just define our terms about what originalism is. Originalism is the claim that the meaning of the Constitution should remain the same until it's properly changed, and it's properly changed by amendment under the terms of the Constitution. So the meaning of the Constitution should remain the same until it's properly changed by amendment. That's all originalism is. There are then two unifying principles or precepts that unite originalism, because originalism isn't a single theory. I did refer to original meaning. That is one theory of originalism. Originalism is a family of theories that bear family resemblances to each other, the way your kids will resemble each other and they'll resemble a parent. That's what originalism is, a family of theory. And it's in this family, the thing that unifies the family are two precepts. The first is the fixation thesis, and the second is the constraint principle. The fixation thesis is the empirical claim that the meaning of the text of the Constitution was fixed at the time that it was enacted, that it had a fixed meaning at the time it was enacted and then communicated to the general public. That's a descriptive claim about the way language works. It could be disputed on the grounds that language doesn't work that way, that meanings aren't fixed. You can do a lot of, all of these propositions are contestable, but it's an empirical claim that would be contested empirically. The second precept, which is the constraint principle, is a normative precept. It's a normative principle. Therefore, it needs to be justified on normative grounds. And it is the principle that constitutional actors ought to conform their conduct to the meaning that's fixed in the original meaning, or in the text of the Constitution. I want to get to original meaning yet. In the text of the Constitution. So that's the constraint principle. It's a normative principle. There are multiple normative arguments for why constitutional actors ought to conform their conduct and adhere to the meaning that's fixed in the Constitution. But a normative claim needs to be contested normatively and can be contested normatively. Now, with respect to original meaning versus original framers' intent, there was a time in which originalism was very closely identified with the intentions of the framers. In other words, the intentions of the framers would be what fixes the meaning at the time it's enacted, as opposed to the original public meaning thesis, or the public meaning thesis, which says that the meaning that's fixed at the time of enactment is the meaning that's communicated to the intended audience, which is the general public. And that is therefore the meaning that's fixed. So the difference between original framers' intent originalists, of which there are still a few, and original public meaning originalists, which is the overwhelming number of both scholars as well as judges today, are original public meaning originalists. The disagreement here is about what exactly it is that's fixed at the time that the Constitution is enacted. So it's a dispute about the nature of fixation and what exactly was fixed.
You argued very convincingly, in my view, that the Ninth Amendment is a vital part of the Bill of Rights, a part of the Constitution. However, the language is vague. That just because I'm not going to quote it exactly, but just because
I'll quote it exactly. The
okay.
enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Okay, so obviously that doesn't mean that we have any right we claim we have. So how do you interpret that properly and construct it properly?
Well, first you try to identify what its meaning was at the time it was enacted. There's a lot of words in the Ninth Amendment. And in fact, doing word searches or doing corpus linguistic analysis of each of the words of the Ninth Amendment gets you almost nowhere because all of those words were very general use. Rights, retain, people. If you take the word separately and try to break it down, it doesn't really get you anywhere. Taken holistically, when it's a reference to the rights retained by the people, um, um, is a descriptor historically justified, I think, by evidence. It's a descriptor of natural rights. Natural rights are the rights that precede the formation of government, precede a constitution, and especially the unalienable natural rights are the ones that are retained by the people when they form a government. That is actually the philosophy that was articulated in the Declaration of Independence. And the theory in the Declaration of Independence that they held to be self-evident was that all men are created equal, that they are endowed by their creator with certain inalienable rights, among which are the rights of life, liberty, and the pursuit of happiness, each one of which are individual rights. They are not group rights. And then the next sentence says, and the next sentence is really important, the next sentence says, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So this gives you the American theory of government, which is government exists among men, and government is not the same as us. We are not the government. The government is not us. This actually signals the agency theory of government. Governments are the agents of the people. Governments are instituted among us, among men, to secure these rights. Which rights? The rights that are referenced in the previous sentence, the rights to life, liberty, and the pursuit of happiness. And what are those rights? Inalienable natural rights are what those rights are. Now, this is not a libertarian theory of the Constitution. It is not Randy Barnett's theory of the Constitution. It was adopted unanimously by the Congress of the United States. It is the American theory of the Constitution. And the rights retained by the people in the Ninth Amendment is a callback to the Declaration's affirmation that there are pre-existing inalienable natural rights, among which are life, liberty, and the pursuit of happiness, that governments are intended to secure. Then the Ninth Amendment goes on to assert that putting some of these rights or putting any rights in writing by enumerating them in the text of the Constitution should not be construed to deny or disparage these other pre-existing rights that are retained by the people after they enter into civil society and they form a government. So that is the level of meaning. That is, I think, more or less as far as meaning will take us, other than to describe in the more abstract sense what natural rights are: life, liberty, and the pursuit of happiness. There are other formulations of natural rights as well. The one that was actually even more prominent than the declarations was the one in the Virginia Declaration of Rights, which lists out some of the rights retained by the people, and they got incorporated into state constitutions. I don't have those at my fingertips to recite to you at this moment. Um, um, I mean, it does include the right to acquire and enjoy and use property and enjoy the security and the pursuit of happiness as well. Happiness and the pursuit of happiness and safety. But having said all that, what I think you might actually be asking me about is not the interpretation of the Ninth Amendment, but the construction of the Ninth Amendment. How do you put it into effect? How do you give it legal effect? And here is a very good example of why you want to distinguish between interpretation and construction. Because I could say a lot about the meaning of the text of the Ninth Amendment. Most everything I said about it is not controversial. That is, pretty much any scholar will agree with that. What people disagree about is what legal effect that provision should have. And that is something that's something described by the activity of construction. Then we then have a debate about how you implement that. Do you implement that? Should judges be implementing that? Who should be implementing that? Those are very good debates you can have, but they're not necessarily about the meaning of the Ninth Amendment. They're about how and whether to give it legal effect.
As a contemporary example, I personally hold that the war on drugs is violative of the Ninth Amendment. My evidence for that is that there was no war on drugs at the founding of the country. Drugs like cocaine and it wouldn't have been heroin at the time, morphine, uh, were perfectly legal at the federal level at the founding of the country. To outlaw alcohol required a constitutional amendment. So why wouldn't the Ninth Amendment's provision of rights apply to the right of people to ingest whatever they want into their own bodies? Would that be, in your view, an accurate construction?
I hesitate to get into any given claim about an unenumerated right, because to establish an unenumerated right requires more than sort of off the top of your head, or what is sometimes called armchair originalism. But let me begin by saying that the Ninth Amendment signals a constraint on federal government, like the rest of the Bill of Rights were a constraint on the federal government. The Bill of Rights that the Ninth Amendment is qualifying and saying, don't interpret it this way. Don't interpret it as a way to disparage natural rights. The Bill of Rights, what we call the Bill of Rights, which was not actually even called the Bill of Rights for a century at least, are constraints on the federal government, not constraints on state power. Most of the laws that are challenged as constitutional, now there are federal drug laws for sure, but much of the laws that are enforced are state drug laws. The Bill of Rights really says nothing about that. The extent to which there is federal jurisdiction, federal either judicial jurisdiction or congressional jurisdiction over the states and state laws, it's something that is a 14th Amendment question. And you would have to then ask whether the 14th Amendment is violated by state laws. It wouldn't be something that the Ninth Amendment would directly apply to. What the Ninth Amendment signals is that there are natural rights. And these natural rights are not surrendered to government. They are retained by the people when they form a government. What the juridical status of these natural rights are is a much more complicated subject. How constitutional actors are supposed to be taking that into account, either legislators or judges are supposed to be taking that into account, is a really much more complicated question.
A key or maybe a fundamental assumption of yours or an operating premise in constitutionalism is that we should operate on a presumption of liberty. First, what is a presumption of liberty and why should that be our operational premise?
Okay, that's a great question. The subtitle of the book you were referring to, Restoring the Lost Constitution, is the presumption of liberty. And another great reason for why you want to distinguish interpretation from construction is that the presumption of liberty that I propose in that book, and which has some historical foundation, is a proposed rule of construction. It is not a claim that the original meaning of the Constitution contains within it a presumption of liberty. And so when people sometimes characterize my work as providing a libertarian theory of the meaning of the Constitution, I reject that, because I think I'm just trying to figure out what the Constitution says, whether it's libertarian or not. And then when you come to put it into effect, I do think that the Constitution should be interpreted in a rights respecting, liberty protective way. And one of the ways to do that would be to adopt a presumption of liberty in which the burden is then placed on the government to justify its prohibition of wrongful activities or its regulation of rightful activities, which are two things within its power to do. Government may justly prohibit wrongful acts, and it may justly regulate rightful acts. But to do either of those things, it must show that it is appropriately doing those things for an appropriate governmental end, which is first and foremost, the protection of the health and safety of the public and the protection of the rights of other people. Those are the most fundamental governmental ends that there are. And so a presumption of liberty, all a presumption of liberty says is that the burden is on the government when it chooses to either prohibit some conduct or to regulate rightful conduct. Prohibit wrongful or regulate rightful conduct. The burden is on it to come forward and show what is the end it seeks to be achieving, and is there some evidentiary basis for believing that the means it has chosen are conducive to that appropriate end. The burden should not fall, I believe, on the individual citizen to show that an act of government is not justified. Really, if the government is going to go through the trouble, if a legislature is going to go through the trouble of passing a law, it really ought to be doing its legwork before it passes the law. It ought to identify what problem it's addressing and come up and base its decision on evidence, not just on its will or arbitrary desires. And so the presumption of liberty is a means of weeding out arbitrary power. Arbitrary power is power that is done merely because of the will of the person who wants it to be done, or the will of the majority, or the will of the legislature, or the will of the sovereign monarch. And rather than liberty being restricted based on arbitrary power, based on mere will, it needs to be based on reason. It needs to be based on a rational relationship, a real relationship, a substantial relationship between the means chosen and a constitutionally appropriate end.
As I told you before we came on air, prior to reading your book, I had a very difficult time in my own thinking and repudiating anarchism. And the only thing I had really is this just couldn't work. You just end up with competing governments that would, ultimately devolve into some sort of civil war amongst them. There'd be no rule of law, it'd be a breakdown. But I'm a individual rights libertarian, and I couldn't escape their objection that if I don't consent to your government, the government cannot have any authority over me. You masterfully, in my view, destroyed that view. So why isn't consent necessary in order to have a just government?
First, I don't think it's necessary to rebut anarchism. Well, I think what's necessary is to understand what kind of theory anarchism is, anarchist libertarianism is. And it is what you might call ideal theory. Ideal theory is theory that would work in an ideal world. And it's premised on a world of no government. So in a world of no government, there are these individual rights that are natural rights. And anarchist theory claims that such a world would be good. It would be fine. It wouldn't be perfect. It's not a utopian theory. It's an ideal theory, but it would work. It would work well enough. And there are arguments to be made on that on behalf of that proposition. But we don't live in that world. We live in a world of competing national states or nation states. And so what libertarianism needs, in addition to an ideal theory about the state of nature and how the state of nature would work, libertarianism needs what a philosopher would call a second best theory, a theory about the second best. And that is a theory about how liberty is best protected in a world where that does have competing territorial nation states. And that's going to require libertarianism to develop a bunch of sub-precepts that wouldn't be applicable in the state of nature, because in the state of nature, there is no government. And so you don't have to worry about competing governments. And so that's one way to understand or appreciate the difference between an anarchist theory, which you might call an ideal theory. Now, you could dispute that it isn't really an ideal theory. You could say, even in the ideal world of no governments, that won't work. You could obviously make that claim. But I'm just saying we don't need to settle that matter. What we need to settle is, what should a libertarian think about how liberty is best protected in the second best world, in which nation states are a reality. So there needs to be libertarianism for the ideal world, could be one model that would be informative. And then there's libertarian for the real world, which is the world that we live in. And at that point, that's when borders become important, and constitutions become important, and separation of powers becomes important, and all kinds of things become important in the second best world of governments. National citizenship becomes important. Civil rights become important. There's something else that libertarianism as an ideal theory lacks, and that's a theory of civil rights. What are civil rights? Civil rights are the rights you acquire when you leave a state of nature and enter into civil society, and then a government is established. And these are the civil rights that are the legally enforceable rights you receive to protect your natural rights and to protect the rights of others. Libertarianism as an ideal theory doesn't have a theory of civil rights because there is no civil society in the ideal world, in the ideal libertarian world. And so libertarians need a theory of civil rights. Now, the Republicans, first of all, the anti-slavery constitutionalists in the early 19th century, who I believe to be the original libertarians, which were the anti-slavery abolitionists, who, by the way, also ended up being anarchists as well. But those original libertarians did develop a theory of citizenship, in which citizenship is like membership. There used to be an old American Express commercial that said membership has its privileges. Well, citizenship in a particular polity has its privileges and immunities. These are what we call privileges or immunities of citizens of the United States, which, by the way, the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So libertarians need, constitutionalists need, an originalists need a theory of privileges or immunities, and libertarians need that as well as a matter of second best theory of libertarianism for the real world. Oh, now, wait a second. You asked me about consent.
Yes.
So I didn't answer your question. You're making a reference here to Lysander Spooner's rather famous, at least within libertarian circles, famous essay, No Treason, the Constitution of No Authority, which I read when I was an undergraduate, and I found extremely persuasive. In fact, I found it persuasive even when I took constitutional law in law school. And that is the idea that the Constitution, which is defended by many people as a contract of some kind, doesn't have the indicia of a contract even for the sale of a $25 item or a $50 item. That is, its terms are not clear, and you're never asked for your consent in the way you are before you rent a car or buy a house or purchase anything in the store. You actually have to manifest your intent. When you go online, you have to click I agree before you get a whole bunch of stuff. You don't have to do that when it comes to the Constitution. It lacks the kind of Spooner's argument was it lacks the kind of basic consent that even the most mundane of contracts can exist for even the most mundane of contracts. I think he's right about that. But I think where he misses the point, or where that argument misses the point, and I'm, by the way, a huge admirer of Lysander Spooner. Can I just do a digression here about Spooner for a minute?
Sure.
I'm a big admirer of Spooner. I became an originalist because I read Lysander Spooner's 1845 book, The Unconstitutionality of Slavery. And before I left Boston University to go to Georgetown, I raised $10,000 to put a 6-foot granite obelisk on Spooner's grave in Forest Hill Cemetery because it had been marked only by a bronze plaque that was flush to the ground. So now he has a nice monument there. I also erected a monument at his childhood home I'm just drawing a blank on Athol, Massachusetts, So I'm a huge Spooner fan. I don't mean he's right about everything, but I think he's somebody that's a very important figure in our history. What I think Spooner misses here, and people who would accept this argument, like me, who accepted this argument, is the idea that the reason why laws can be justly enforced against us is not because we consent to their enforcement, but because those laws are sufficiently just. And by just, I mean those laws do not violate our rights, and they are necessary. So they are not improper because they don't violate our rights, and they're necessary to secure the rights of others, to protect the rights of others. And you have a duty to follow those laws. For the same reason, you have a moral duty to respect the rights of others, because those laws are a necessary means for the protection of the rights of others. So the moral duty you have to adhere to the rights of others, which Spoonerian type libertarians would agree with, are the same reason you have a duty to obey laws that respect the rights of others, that are necessary to respect the rights of others, provided those laws are really doing that and not doing something else. And that's exactly why I think you should have a presumption of liberty, to put the burden on government to show that their laws really are necessary to the protection of the rights of others, and not an improper restriction on the rights of the individual upon who they've been imposed. If both of those criteria are satisfied, if a law is necessary for the protection of the rights of others and do not restrict unjustly restrict the rights of the people on whom they're imposed, then you have a duty to adhere to those laws, regardless of whether you consented to them or not. Consent is irrelevant. Every bit as much as irrelevant as when I was a criminal prosecutor in Chicago, prosecuting murderers, rapists, and armed robbers. I did not get jurisdiction to prosecute them because they consented to it. The jurisdiction I had to prosecute them was under the assumption that they were guilty of murder, they were guilty of rape, or they were guilty of armed robbery, and that's what justified their prosecution. Now, the burden was on me as the prosecutor to prove this was true to a neutral fact finder like a judge or a jury before they could be justly punished. But the justification for their punishment was their wrongdoing, not their consent. And that's what we have to keep in mind.
Excellent point. Now, you've had quite a career. You're a constitutional law professor. You've written books and articles. You've argued before the Supreme Court, and now you've written your memoir. So, what
There it
led
is.
you? There it is, A Life for
There it is.
Liberty. Yes, the
The
making of an
making of
American originalist.
correct.
So, what made you decide to write your memoir, to put down your story on paper?
Very simple. I had grandchildren, and I realized that by the time they were old enough to know what their grandfather had done, I wouldn't necessarily be able to explain it to them. I wouldn't be necessarily around to explain it to them. And then it turns out, as you say, I've done so many things, I could never get them to sit still long enough to hear the whole story. So I just set out to write a memoir for their benefit, and that's who the book is dedicated to my grandchildren, and I think also to their children. I think it would have been good for them. I would like to have known more about my ancestors and what they did. I know a bit about them, but once we get past my great grandfather on my father's side, I know nothing about them. And I would like to know more about them. And I thought that I've done so many interesting things that it would be good for them to know I did. So that's what motivated me to set out to do it. And then as the project developed, I could see other purposes for it, like teaching lessons to people as to how they can have a life like I've lived. They can achieve what I've achieved. I've had an extremely enjoyable life and a very rewarding life, and one that I believe in which I've been able to remain true to my first principles of justice and individual rights, etc. And I thought that if they could see how it could be done, that would be beneficial to them. Let's put it this way. If you're in high school or college, and you look at somebody like me at my level of achievement and maturity, I'm 72 years old and I've, been at this game for a long time. You're likely to say, well, that's fine for him, but I could never do that because, he is this, whatever, really smart guy and et cetera, but I'm not, I could never be that. And this is an entirely unfair comparison. You couldn't compare the 18 or 19-year-old Randy Barnett to the 70-year-old Randy Barnett. There's just no comparison between the two. And so it's also unfair to compare an 18, 19-year-old anybody else. So I think that by telling the story of how I got to be where I am today, beginning where I grew up and what my childhood was like and what I did in my childhood, to get there, including a very candid account of all the mistakes I've made along the way, so that people won't have to make the same mistakes I did. I thought it would serve a really important value. Then there was another objective that emerged, and that is that my life and career spans the origin of modern libertarianism and modern originalism. And I have been a very, very deep participant in the development of both of those intellectual models, both the libertarian model, which I first came across when I was in college and became very active in college and in law school, and the originalist model, which I came across much later. As I say, it was Lysander Spooner's book on the unconstitutionality of slavery that first sold me on originalism. So the book also tells the story of the modern libertarian movement, And it tells the story of a first-person story of the modern originalist movement that I've participated in since the founding of, essentially the founding of both.
So what's a highlight in the book or some highlights from your long career? I
Well,
believe you argued for marijuana in front of the Supreme Court. I mean, you've
right.
got quite the career.
Well, the book starts actually, it doesn't go in strict chronological order. It uses what authors call a fractured narrative. It starts with the Raich case, which is the Gonzalez versus Raich case, the medical marijuana case that came out of California and the Ninth Circuit, in which I and two other lawyers brought the lawsuit on behalf of Angel Raich and another plaintiff, Diane Monson, to challenge the constitutionality of the Controlled Substances Act as applied to individually possessed and cultivated marijuana for that was raised for cultivated and used for medical purposes and authorized by state law, authorized by the Compassionate Use Act of California. We argued that that the federal prohibition of this act that had been legalized by the state was unconstitutional. We brought that challenge. I took that challenge all the way to the Supreme Court, and I argued it in the Supreme Court. And the book starts with where that challenge came from and how my involvement in the medical marijuana stuff got going, how it started, how it grew, and what it was like to argue in the Supreme Court. And it's after telling that story and also discussing sort of the legal theories that we had and what the legal theory that was adopted by the court. It then goes back to my childhood and leads through the story of how I got to that position. And before reaching the challenge to the Affordable Care Act that I spearheaded as a law professor, I developed the theory about why the individual insurance mandate in Obamacare was unconstitutional, which got all the way to the Supreme Court again. I didn't argue that case, but I was one of the lawyers representing the National Federation of Independent Business. So it talks all about that case. And finally, the final part of the book, it talks about a couple of things. It talks about the fact that I became a senior advisor to Rand Paul in his presidential campaign in 2016 and got close to him. And I proposed a constitutional amendment called the Repeal Amendment that was introduced into both houses of Congress before it basically went nowhere after that. And finally culminates in the selection of originalist justices to the Supreme Court and originalist judges to the court. And that's sort of the culmination of the book before a final chapter on what's next, which is what's next for libertarianism, what's next for originalism, and also what's next for American Jewry, since I'm Jewish, I was raised Jewish, and obviously being a Jew these days in America, as well as the world, has its challenges. And so the book is also, it tracks my being a Jew all the way through the book and the relationship of my Judaism to everything else that I did. And it also talks about what's the future for American Jews. So that's the big picture of what the book covers. Starts with the Raich case, then builds up again to the NFIB case, and finally talks about how we got so many originalist justices on the court, which is something that if you had told me about when I was a law student reading constitutional law cases in the 1970s, that I would have thought this was a pipe dream. What are you smoking to tell me that we would finally be 30 or 40 years later in the position that we are now, and due in some measure to my own efforts that I had a role to play in making all these events come to pass.
You
Oh, can
mentioned,
I
oh
can I
yeah,
say one more thing about
sure,
the book?
absolutely.
Which is a lesson that I learned in the course of writing it. And it was not something I expected when I set out to write it. And that was the importance of mentors, because the book in some ways became a tribute to all the mentors that I had who helped me along the way. We don't get to be who we are by ourselves. And I had crucial mentors, beginning with my father and working through a bunch of other mentors who I essentially give a testimony to in the course of writing this. And that also highlights for readers, young readers especially, the importance of cultivating your mentors, being a good protege, means being a faithful, good protege, cultivating mentors, and then also thanking them for what they've done for you while you still can before they pass from the scene. I was very happy that I was able to thank most of my mentors before they passed from the scene. Not all of them, but I did manage to thank some of them, even if it was up to the last minute. I was able to personally thank them. So, cultivate mentors and then thank them after after they've been a good mentor for you.
That's beautiful. You mentioned being Jewish in America. And while I'm an atheist, I do have a Jewish last name. I have a Jewish background. And what I've noticed, I don't know, the past 6 months maybe, and I'm curious what your thoughts are on it. It seems like either there's more anti-Semitism now than there has been in the past, or the Jew haters are just becoming more brazen. Now, I preface that with I'm getting this from my social media feeds, which I understand are not an exact replication of the population, but I'm curious, do you see an uptick or an increase in Jew hatred in this country?
Well, there's no question there's an increase in anti-Jewish acts of terrorism and intimidation against Jews in this country, visible Jews in this country, on the streets of New York, on the streets of Los Angeles, most blue cities. This is where tends to be happening. There's no question that there's an uptick of this. I mean, one of the thing that the book does talk about, and it was written before this uptick happened. It just, by the time I got to the end of the book and wrote my afterword, I was able to take some of this I was able to take October 7th into account. But the book was written substantially before that. It goes back to the fact that I got into a fist fight with a kid in second grade on the playground when he called me a dirty Jew. It wasn't until years later that I realized the kid really didn't necessarily have any way of knowing that I actually was Jewish. It just was an insult you hurled at people. But I fought him. I initiated the fist fight because he called me a dirty Jew and vowed that I would fight anybody who called me a dirty Jew. Well, I got older and the bad guys got bigger and tougher. I modified my policy. I went more to I'm going to avoid fights if possible, but unless they find me. And the book actually does discuss the various fights that I did get into over my life in my youth. But so I think anti-Semitism has always been with us. My dad, who is very realistic about things, said both America is the promised land for Jews and it can happen here because it can happen anywhere. The meaning Jew hatred can happen anywhere. So I had a very realistic view. Unlike many Jews who've grown up in Jewish enclaves, I grew up in a Polish Catholic town and understood the marginal nature of Jews in the country, that people who grew up in Scarsdale or Skokie, otherwise in Westchester County or LA, they don't necessarily see how marginal Jews are numerically in this country. Now, having said that, what to make of the uptick of all of this anti-Jewish violence and anti-Semitic rhetoric? I actually think what we're witnessing is an organized anti-Jew campaign that's been organized by Islamo-fascists coming from the Middle East. That is, I think that Middle East governments who have a lot of money to fund Hamas and Hezbollah and other terrorist organizations have organized in this country these groups, these demonstrations that are these so-called demonstrations or protests, which are nothing more than mobs attempting to intimidate Jews, are not spontaneous. They are highly well organized. They are well funded. You'll notice that at all the encampments at all these schools, everybody had the same the pop-up tents that were purchased from REI or wherever they got them from. What we lack in this country is a Justice Department who is going to investigate sort of the sources of this funding and the organization for this terrorist activity in the way that the Department of Justice was formulated to investigate terrorist activity by the Ku Klux Klan and other anti-Black organizations. This is really what the DOJ is there for, but they're not doing that. And so I don't think we're witnessing spontaneous anti-Semitism. I don't think we're witnessing some tapping into some deep well of American anti-Semitism. I think there's always been some, there always will be some. And social media does allow those who hold those views to amplify their voices. But I think what we're actually witnessing in the form of genuine violence towards Jews is an organized, internationally funded campaign. And it needs to be combated the way we used to combat domestic terrorist organizations like the Ku Klux Klan. But right now we have an administration that is absent without leave with respect to this organized terrorist campaign. And I think only the hope of another administration with a different head of the DOJ and FBI can empower pushback. At the moment, Jews are going to have to defend themselves, which is one reason why I'm a strong supporter and have always been a strong supporter of the right to keep and bear arms, in part because of this reason. And it's always been because of this reason.
Before I let you go, and correct me if I'm wrong, but I believe that you and Richard Epstein differ over the concept of inalienable rights. Am I right about that? Where he thinks there's no such thing as inalienable rights, and you hold there are. Or am I mistaken about this?
I'm going to have to let Richard speak for himself. I mean, I've known Richard since I was a law student. And I was a research fellow after I was a prosecutor, I went to the University of Chicago as a research fellow under his sponsorship. So I've known him for a very long time, but I honestly don't know what his views are on the existence of natural rights or inalienable natural rights. So
But you hold
you're going
that
to have,
there are inalienable rights, right?
yes,
That's your
I
view.
do.
Okay, I interviewed him and he told me he doesn't hold he thinks that there's no such thing as inalienable
Well,
rights.
let me just tell you how I define it, what I
Okay.
mean by inalienable right. An inalienable right is a right that you can't give up by your own consent, even if you want to. And so I'll give you an example of that. You have an inalienable right to your own bodily integrity. That's something you can't give away, even if you consent to it. Supposing you consent to get into a WWF prize fight ring with some guy, and you consent to it. You sign a contract saying, hey, I'll box this guy, I'll fight this guy, put me in the cage. And then when it comes time to put you in the cage, you say, well, I've changed my mind. I think I think you could be in breach of contract, in which case you might owe damages, but they can't throw you into the ring and say, no, 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 you've already consented to that. You can do this. If the right to control your own body is inalienable, you cannot be, in part because it literally cannot be alienated. If I want to sell you my car, I can just hand over the keys to the car and you can drive off in it. I can't sell you my body in the same way I can sell you my car, because no matter what I say and no matter what you do, my mind still controls my body. It's still mine. I can't give it away. And our consciences, our thoughts are inalienable. We can't give them away even if we wanted to. And they are ours by right. And as to why it's by right, that's a longer story. So I do think
Sure.
that certain rights are inalienable. They can't be given away. The reason why the founders were so adamant that rights were inalienable is the British argued that the Americans had alienated their rights to self-government by consenting to the jurisdiction or authority of Parliament. And the Americans said, number one, we didn't consent to the authority of Parliament. And number two, even if we had, this is an inalienable right that we could always withdraw and bring it back to it. We can always bring it back and regain it again. And that was one of the reasons why the inalienable nature of these fundamental rights was so important to them, because they were being challenged by the British government, who claimed that they had alienated their rights. So anyway, Richard can speak for himself, but that's my view on inalienable rights.
Well, that's a fantastic place to stop. And thank you so much for taking the time to be with us today. Where can people find you and where can they find your book?
Well, they can find me on Twitter at Randy E. Barnett. They can find me online at randybarnett.com. And they can find my book, A Life for Liberty, The Making of an American Originalist, on Amazon. You can pre-order that book. It'll come out by July 2nd. So when many people listening to this podcast, the book will already be published on July 2nd. And I think you'll enjoy it. As also, I have to say, because people always ask me, it has pictures. It has black and white pictures. It has some great color pictures. I have a wonderful picture of Murray Rothbard pretending to be a movie mogul at the side of his swimming pool in Palo Alto, California, that I took myself. And so there are it's a fun book. It's hopefully an entertaining read. It's one of the few books my wife has read and says that she likes.
Well, that's excellent. Well, thank you so much, Professor. I hope you have a great day and I hope the book goes well and all goes well for you.
Thanks, Michael. Thanks for having me.
Take care.